Well, thank you so much for joining us here on our TV streaming app WLTX Plus. I'm Whitney Sullivan. Now, the big story right now, what everyone's still talking about. A Richland County jury found Rick Chow not guilty in the shooting death of 14-year-old Cyrus Carmack-Belton. Belton's family, who was in the courtroom, broke down in tears after the verdict was read. I mean, his mother looked like she had to physically be helped out of the courtroom. And joining me now to talk about everything that happened throughout this trial is defense attorney John Mobley to break down what happened inside the court and how the jury reached their decision. Thank you so much for joining us.
Thank you. It's my pleasure.
All right. So the first question I have to ask, were you surprised when you heard them say not guilty?
Well, Whitney, as always, I got to call it like I see it. To say I was shocked would be an understatement. When I looked at so many factors in this case, the ones that I call the intangibles, when you have this defendant who they're trying to portray as this humble shop owner, yet he's surrounded by three of the most expensive, well-known defense attorneys in the state. I didn't think that was a good look for him. I thought that made him look unsympathetic. I thought that made him look like the jury's thinking, man, maybe they've got a strong case against him that needs all these lawyers. I didn't like the from the defense standpoint, the dynamic that the person that was shot and killed was a teenager and actually had not committed any crime. It wasn't on the premise. I think, going into it, that although they had a job to do and they were doing a very great job with this defense, that the deck was stacked against them. So again, I was shocked to say the least.
And we're seeing that echo across social media, where there are a lot of community members who were shocked by the outcome of this as well. So that leads me to my next question. Where do you think things possibly broke down for the prosecution in presenting this case?
Well, I will say this as a caveat that, I do a lot of commentary on legal cases, and it's always difficult to critique the lawyers that just out of respect and courtesy. I know all these prosecutors. I've tried cases with them. I've worked with them. I know the defense attorneys. I know the judge. So, however, you kind of have to, be straight on something like this, and yes, it's Monday morning quarterbacking, but, from opening statements, one of the vast contrasts that I saw between the prosecution and the defense, where I believe the prosecutors dropped the ball, is they didn't really do much to humanize the victim in the case. And I remember listening to both opening statements. And while the prosecutor, the solicitor, did mention he was 14 years old, that was kind of it. Had I been prosecuting that case, I would have talked about not only his age, but where he went to school, what he liked to do for fun, what video games he liked. I would have wanted to bring him to life so the jurors could have some image of this young man, this life in their mind, and they just didn't do that. Something I would have done differently if I was a prosecutor, and I don't think that they really leaned into the fact that this teen was hunted. They talked about him being chased out of the store about a bottle of water. That was kind of their big theme. They kind of hung everything on that, all about a bottle of water. This teen was hunted. Mm-hmm. I mean, 130 yards. And I remember when, in opening statements, when they talked about that, one thing I thought was great was he described that it was that 130 yards would be the equivalent of a football field, goalpost to goalpost. Had I given that opening statement, I would have had that picture up there. I would have had a visual picture of a football field from goalpost to goalpost, so the jury could see how far they hunted. These two grown men hunted this 14-year-old. And I would have used that word. I wouldn't have said chase. I would have said hunted. That's how I would have really portrayed this, and which I think is accurate, quite frankly. Now, on the flip side, the defense, in their opening statement, they talked about the defendant's credentials and how he came to America and how he built his business and his family. They gave the jury all this information to humanize this person. So, I mean, big difference. I think that made a big difference in the jury's mind because they can identify with one side more than the other. And, something else that I would have done different when it came to the issue of whether or not the young man actually had the gun or pointed the gun, I would have used a strategy that I call legal judo. Judo was a martial art where you use your opponent's weight and strength against him. And, the defense was always He pointed the gun, he had the gun, he pulled the gun out. And, the prosecutors, I think for the most part, they tried to argue that he didn't. I would have taken a different position. I would have said, yeah, he did pull a gun out. You know why? Because these two grown men were hunting him and he couldn't get away from them. And he was justified in doing so, and kind of taken away that argument. And I think most people could understand, well, yeah, you got these two grown men chasing him. He's trying to get away. He's falling down. They won't let up. He didn't do anything wrong. He's seen what's happened to people. Hey, I would have pulled the gun out too to defend myself. So I would have leaned into that a lot more if I was the prosecutor, instead of trying to argue it didn't happen. So, but those are some of the things that kind of stuck out in my mind as being significant in this case.
And speaking of the way you would have approached the situation about the gun, we actually heard from the family's attorney, Cyrus's family's attorney, who said something very similar, saying everybody kept asking, why does a 14-year-old need a gun? And he said, this case is an example of why a 14-year-old needs a gun, because he was hunted down by two grown men. Now, one of the biggest conversations that I am seeing happening on social media is the question of, why did the state choose to charge him with murder instead of manslaughter?
Well, the elements. This case really was not a manslaughter case. Manslaughter requires some type of legal provocation, and there was no provocation. There was no heat of passion in this case. This was a murder. I agree with that decision. So based on the elements of murder and manslaughter, and had I prosecuted this case, I would have indicted him and charged him with murder as well.
What is the burden of proof? What does the state need to prove in a murder case? And do you think the state met that burden of proof?
In every criminal case, whether it's a traffic ticket, a DUI, a possession of marijuana, a murder, a death penalty case, the burden of proof on the state is always beyond all reasonable doubt, which in South Carolina is defined as the kind of doubt that would cause a reasonable person to hesitate to act. So again, from the standpoint as to whether or not they met their case from a technical standpoint, I see from a factual and legal standpoint that they met their burden. However, I think what I describe are intangibles in the case. The intangibles are things that I described about the manner in which the case was presented, some of the strategies that were used that would impact jurors. I think the intangibles are where the prosecutors lost in this case.
And speaking of, we talked about Monday morning quarterbacking when it comes to the prosecution. Is there anything on the defense side that you're like, I would have done better, even though they did get their not guilty verdict? Or do you think that there was something that they did that really helped push them to get that not guilty verdict, something that they excelled in?
Well, I got to say this, as much as I respect all those lawyers, I was surprised that they didn't put up more. And when I say that, again, like I said a minute ago, I mean, I've tried murder cases that were substantially more complicated, that had more witnesses, experts, more forensic evidence, more fact witnesses, more defense witnesses, more complex legal issues by myself, okay? So when I see this case with these three attorneys, I mean, this case did not need three lawyers. So when I saw this many lawyers, I'm thinking, okay, they're going to have some experts, maybe some custom, exhibits or animations showing what happened, some technical, complex, BMW defense, and they didn't. I mean, they did what they had to do. I mean, but they called three witnesses, an officer, an EMS worker, and the defendant's son. And I was just shocked. I was absolutely shocked that there wasn't more. So obviously, they made the right decision, but I was just surprised that they didn't put up a greater number of witnesses and put what I thought was going to be this Cadillac of defenses based on the team of lawyers that he had.
Let me ask you this. I personally want to know, how do you decide if you're the defendant, how many lawyers you're going to have on your team? Like, we know how it works for the state, but sometimes we see defendants with one lawyer, two lawyers, three lawyers. Whose decision is that, and how is that team built?
Well, I mean, generally it's going to be the client based on his budget most of the time.
Wow,
because,
okay.
I mean, the reality of it is all these lawyers have to get paid. So you can want all the lawyers you want, but you kind of got to be able to afford them and pay them. Now, it's not uncommon for lawyers to bring in a second attorney or a third attorney to help with a complex case and to kind of divide the case up. If you have a case that's a lot of witnesses and a lot of issues and very complex, I didn't see it as this type of case. And I know he had the defendant had some very good lawyers in the beginning, the Sheelys, and for some reason, after he lost the stand your ground hearing, the Sheelys are no longer on the case, and he hired Jack and Joe and Sean, and again, all great lawyers, all individually, great lead counsel in their own right. So, but I cannot say what purpose or what he was thinking by bringing in such a big team on the facts of this case.
Yeah, that was definitely a very large team. When you look back at the trial, were there any moments that really stood out to you, whether for the defense or for the prosecution?
No, I mean, there really were not. I mean, and that's something I was looking for. I was looking for, that moment, that blockbuster, that bombshell moment that normally helps define a trial. Because I think, if I'm trying a case, whether I'm prosecuting a case, I used to be a prosecutor, which has been a long time ago, like another life. But if I'm defending a case or litigating a personal injury case, I'm always looking for something. Yeah. I'm always looking to create that defining moment, that bombshell, that blockbuster that's going to stick in the jury's mind, that's really going to be something that, makes a difference. And I just didn't see it in that case. I kept looking for it. I kept waiting for it. I just did not see it in that case.
I want to talk about the high-profile nature of this case. I mean, this is one of the most high-profile, most talked-about cases that we've seen locally outside of Murdaugh in a very long time. Do you think that the publicity, the attention that this case received played any role in the outcome of the verdict, or does it put any extra pressure on the defense or prosecution?
Well, I will tell you based on personal experience. I have tried defended a number of high-profile criminal cases across the state that receive media attention across the country. I will tell you, the answer to your second question is yes. It definitely puts more pressure on everyone because you're under a microscope. Everyone is watching. And it's already stressful enough when you have the weight of defending someone's liberty on your shoulders, but when you have all the cameras in the courtroom and there's extra pressure, there's no doubt about it. It adds more pressure to everyone involved, even including the judge. So, with respect to whether or not, in my experience, it affects the outcome, the answer is no, because I've gotten mixed results. I've defended cases, murder cases that I thought was going my way, I thought was going great, and I'm going to win, and I get a guilty verdict in less than an hour. I've defended cases, violent crimes, homicides, where I kind of felt like the lamb going to the slaughter, and they're high-profile cases, and gotten not guilty verdicts in shorter time periods. So it's been my experience across the board in multiple counties around the state that the media publicity really does not affect the jury's decision in these cases.
I want to talk about prosecution's next steps, if there are any. Another big thing that I am seeing people talk about on social media is, outside of the fact that they were wondering, okay, why wasn't he charged with manslaughter? The question is, can he be charged, Rick Chow, with any other criminal charges moving forward?
Well, in state court, it's game over. It is double jeopardy. Once someone's prosecuted in the state court, and there's a decision, a not guilty verdict, they cannot be retried again. They can't go back and add another charge. Prosecutors try to do that. They'll say, okay, well, we charge him with murder. We didn't charge him with kidnapping. We're going to go back and indict him for kidnapping because that's a different crime. No, same set of facts. Any offense that's related to that set of facts, they cannot prosecute him for again. It is double jeopardy. Now, it is certainly possible, I can't say with any degree of certainty, that they could investigate the possibility of federal charges. I'm going to remind everyone of the case of Michael Slagle, the cop that shot the black man in Charleston, shot him in the back, running. Some similarities there. And a Charleston jury found him not guilty. He was later prosecuted in federal court for civil rights violations. However, the distinction is in that case he was an officer acting under the color of authority. This defendant was not. So the question would be whether or not there might be an appropriate federal civil rights type violation charge that they could charge him with as an individual. I don't think that's in the realm, out of the realm of possibility. I mean, Don Lemon, he got indicted for conspiring to violate a church's civil rights in a protest. So I do believe if they were so inclined, they could find an appropriate federal criminal charge or statute to indict Mr. Chow. Now, whether or not they're so inclined, I think is unlikely based on the current administration.
And speaking of the current administration, what does the prosecution do next after a loss like this? Do they go back and restudy the case and maybe see where they could have done better? What happens after a loss like this, or do they go ahead and move on to the next trial?
Well, I mean, they kind of have to move on. There are so many murders pending in Richland County, in every county, they kind of have to move on. I like to dissect cases and revisit what we could have done differently. That's what I would do in this case because, I mean, you know, the murder cases are some of the most important cases in that office. So you want to get your best results on those cases, your violent crimes, your murders. And so I think they would be wise to dissect it. And I would say dissect it with non-lawyers because I believe that oftentimes when attorneys, myself included, are trying to evaluate cases, we're looking at it from a lawyer's perspective. And I think we have to keep in mind at all times that the people we have to convince are not lawyers.
Yeah.
They're jurors, they're laypersons. So understanding and doing some dissecting with laypersons regarding the factors in the case that were significant, the factors that would have made a difference. I've done that plenty of times pre-trial. I mean, you know, they're called focus groups. I'm sure everyone's heard of focus groups where you get a group of people together, a good cross-section of people that might have the same dynamic as a jury, and you kind of, you know, present the facts and evidence of your case and the other side's case and talk about, you know, how that group might decide, how they might vote, and look at why. And it's been my experience in every single focus group that jurors just pick up on things that we lawyers don't think are significant. They will put weight on things that we think are red herrings or don't have any value or any merit. They will fixate and hold on to these things and make decisions based on those factors that we lawyers don't think about, because oftentimes we are so caught up in our heads with the law, with our legal strategy, with our defense, we're forgetting things that they're thinking significant. I would definitely do that in this case.
And I want to talk, now that we know about what could potentially happen on a federal level, let's talk about a civil lawsuit. So we've all learned last night that Cyrus's family attorney, Todd Rutherford, said they will be pursuing a civil lawsuit against Rick Chow. What does that process look like?
Well, it involves filing a lawsuit, of course, against him. I would also say his son. I would sue his son as well, and potentially even the wife that was involved in the initial accusations. And you know, the standard of proof in a civil lawsuit is much lower. It's simply a preponderance of the evidence, more likely than not. I think the big case that everyone can understand is the O.J. Simpson case, where he was found not guilty of murdering his wife and Ron Goldman, but he was later found liable in a civil suit. So it's the same thing, that the standard of proof is lower. And one of the second things that it's important in a civil lawsuit is you have the right to engage in discovery, which you do not have in a criminal trial. And when I say that, when there's a criminal trial, a criminal case, there are things that the prosecutors must give to the defense and the defense must give to the prosecutors, but you don't have the right to make specific requests for documentation. You don't have that full extensive right of discovery, and you also don't have the right to take depositions. And in this case, you know, something I deal with all the time because I handle civil cases, when there's a criminal case is, you know, the defendant you're suing in the criminal case, in the civil case, if the criminal case is pending, he can still assert the fifth and kind of refuse to cooperate. Well, now that the case is over and there's no chance of him being prosecuted, Chow can't take the fifth. They can take his deposition. They can subpoena records. They can, you know, really just, you know, go down the rabbit hole of anything regarding his life. They can actually bring in, and I think something that was important in this case is it was very smart that they didn't put him on the witness stand. Because, you know, we know that there are at least 2 prior incidents where this defendant fired his weapon at shoplifters. But because he didn't testify, that evidence was not allowed in, which is a major coup for the defense. Because I think that would have really really made a difference in the outcome, because they could have portrayed him as this hair trigger guy that's what he does. He sees a shoplifter, he gets mad, he goes after him with his gun. But in a civil case, all that can come in. They can ask him about that, they can explore that, they can call those individuals as witnesses. So I believe the civil case is going to be a much better case and have a much better result and outcome than the criminal case.
What does a timeline look for that civil lawsuit? Is it a situation like for this criminal case, we waited 3 years. Does it take that long for a civil lawsuit?
It can. It can. I would expect the lawsuit has been filed already and just not been served. If it's not, I would get it filed today, because there's a statute of limitations, which is 3 years. But there's no reason to wait on that. Now from there, any civil case, obviously if it gets settled, it can be settled very quickly. But if they want to take the case to trial, you're looking at a good 2 years in this county.
Not just for this case, but for any case in general, when we see people suing somebody, a civil lawsuit, how do they determine the amount of money?
Couple of different ways. The first way is based on insurance. One of the big things in civil lawsuits, which I have to tell so many prospective clients all the time, is I can sue anybody you want me to. However, you can sue somebody for $1 million, but if they don't have it, you're not going to get a dime. You're just practicing, So you have to kind of look at, sources of recovery. So if you have a $5 million insurance policy that's going to defend the case, like a liability policy, well, that's going to be what you're looking at. In some cases, you may look at, a person's assets, which is a much more difficult process, because trying to get assets in a civil lawsuit is just a much more difficult, longer, more uncertain process. So you typically want to always look for some source of recovery. An insurance policy is typically the big thing you're looking for. So I'm certain, obviously, in this case, the convenience store had an insurance policy. He will be sued, and they would probably defend the case and cover the case. And ultimately, we're going to see how much insurance. In litigation, they got to tell you. Again, they have to tell you how much coverage there is. Sometimes you look for umbrella policies. Umbrella means additional policy that's going to provide additional coverage in addition to the primary policy, like an auto or a home or a business policy. People have those. And typically people with a lot of assets will have umbrella coverage to protect their assets. So I think there should be a pretty substantial insurance policy out there that will probably pay in this case.
I want to go back to something that you said earlier when you were talking about the fact that Chow had 2 previous incidents of shooting at shoplifters before this incident with Cyrus. And I was on the phone talking to my mom about it. She was like, I had no idea. Why wasn't that brought up in court?
Rules of evidence. I can guarantee you the prosecutors would have wanted to get that in. And I can guarantee you the defense obviously argued against it under the rules of evidence. Under the rules of evidence, there's something called prior bad acts. And ultimately, under the rules, there are limitations on the admissibility of prior bad acts. The reason behind that rule is you don't want a juror or jury convicting somebody based on things they've done in the past as opposed to the evidence in the case. Because what will happen is people think, well, he's done this kind of stuff before, or he's a bad person, or he is that type of person. He would do something like this and make a conviction based on his character or based on his past conduct. And that's what that rule is designed to prevent. Again, I think if you look at the Murdaugh case, which you talked about, there's no doubt in my mind a big factor in that case was the evidence of the financial crimes. Yeah, because without that, case a little more questionable. But when people think that you're a cockroach or you're a criminal or you're a horrible person, they're more inclined to convict you based on that as opposed to the evidence.
I want to dig into that a little bit
Let's
more.
do it.
This is just the personal question I have. In a case like this has got to be extremely frustrating for the prosecution, because for me, I'm hearing about this. I dug more into those 2 incidents, and I'm like, how does that not apply? Why can that not be brought up? because I feel like it is so relevant, just like the financial crimes for Murdaugh, it's so relevant in establishing the character or pattern of behavior.
I would tend to agree, and I could understand you're thinking that way. You could argue it's motive. You could argue it's intent. You know, the rule does require, you know, similarities, which I think you have in this case. You know, however, you know, the judge has discretion on that. You know, there's another rule that the judge has got to weigh the probative value of the evidence. That's what it says. The rule says the judge must weigh the probative value versus the risk of unfair prejudice. And that's just something that's discretionary. I think that, you know, when it comes to admitting prior crimes or prior bad acts, oftentimes judges can be leery about that because a lot of cases come back on appeal based on the admission of that evidence. And that's something we got to kind of think about. You know, again, using Murdaugh, I mean, this case has to be tried all over again.
And the financial crime, it wasn't just Becky Hill, the financial crimes, they said they did too much.
They did, I mean, and I agree with that. I just thought it went on for way too long. I don't think that the prosecutors could really show the nexus between that and the murders. I mean, honestly, I don't think that theory made any sense whatsoever. And again, if you're prosecuting a murder case, you want the conviction to stick, because if you go too far, even when a judge lets you, when you go too far and you get that conviction, great, well, in 3 years it's coming back, so now your victim's family has got to go through all this again. So that's a consideration that prosecutors have to make, but ultimately the judge makes that decision.
Speaking of judges' decisions, one of the things that I found very interesting before they did closing arguments, the defense asked if the judge would talk to each juror one by one and ask them if they saw anything on social media, if they hadn't experienced anything that might improperly influence their ability to make a fair verdict. Because as many of you know, that Saturday and Sunday they had off and the jury was not sequestered. Were you surprised by the judge's decision to not talk to each juror to make sure that they hadn't seen or heard or talked about this case due to how high profile it is? I mean, during this trial, I have not been able to get on social media without seeing somebody talking about it, and I'm not looking for it like inadvertently.
I'm not surprised. I'm not surprised that he asked, and I'm not surprised that the judge didn't comply with that request. You know, and I want to just briefly kind of just remind everyone what the standard is for jurors. I mean, ultimately, you know, they have to be fair and impartial. That's the only standard. So even if they saw something, I mean, as long as they say they can be fair and impartial, that they're qualified. Now, I will tell you, based on my, you know, my personal experience, that although it's not done in most cases, individual voir dire is much more effective for getting accurate responses than asking questions in a group. And just to kind of make sure everyone understands, you know, when judges ask jurors questions during the voir dire process in the beginning, or in a case like this, if you ask them in a group, what I have found is people are less likely to stand up and volunteer information, because they feel self-conscious, like the spotlight's on them, and they're a little bit leery about that. But when you separate them from the pack and talk to them in private, it's been my experience, based on trials I've been involved in, that they're a lot more forthcoming about issues they have or reasons they may not want to serve on the case or feel comfortable serving, that they don't feel comfortable discussing in a group setting. You know. And typically what I would do in situations to try to alleviate that is, if I had questions that I wanted asked to the panel, I would ask the judge to ask the jury just to raise their hand if they had a positive response. Okay. And then ask them to come up to the bench one by one. So the only people they were talking to were the judge and the lawyers, and they're more comfortable discussing whatever personal issues that they felt were relevant to their service. I found that to be much more effective than just asking the panel, because no one wants to stand up and say, you know, I can't be fair and impartial because I served time in prison for 20 years for something, you know. But I'm not surprised that the judge did not comply with that request.
One of the things, too, that the judge talked about after denying that motion was the fact that he had even been receiving emails related to this case that he said he's now turning over to SLED Defense Attorney Joe McCullough said they've been getting a lot of negative flack on social media. Is that par for the course in trying a high-profile case? Is the feedback that you get if people disagree with the outcome or disagree with you representing somebody? I'm especially seeing a lot of social media pushback for his attorney, Sean Kent.
Well, that's the cost of doing business. I mean, I think you kind of, you want all that love on social media when you put your stuff out there. Well, you're going to get people that don't love you. And you kind of got to deal with that. That's just, if you don't like social media responses, don't put yourself out there like that, because you're going to get that. And not just, everybody gets that. I mean, celebrities, professional athletes, any public figure will tell you that as, for the 10 million likes and positive comments they get 10 million people that hate them, that think they're horrible and losers and should die.
Yeah.
And so I just think, that's just kind of, again, that's the cost of doing business. You put yourself out there on social media, that's something you got to be prepared to deal with.
Yeah, absolutely. It's been very interesting. And just even locally, were you surprised when you heard about the protest? There were protests last night at the gas station.
I'm not surprised. I mean, I hope it doesn't get worse. I would not be surprised if that business is shut down fairly soon.
Yeah. So there are protests with a lot of people saying that they are unhappy with the verdict. You're going to have people who agree with the verdict and don't agree with the verdict, no matter what trial that you have. And there are people who, though, this is a very polarizing trial. Is there anything that the community can do if they didn't like what they saw, or is this just how the justice system works? This is just how it plays out?
This is how it plays out. I mean, and we're not surprised at their protests because, there's a reason. Because the same pattern is that the black community is seen as the unarmed, black man or black teen or black person, or in this case he was armed, just so we're clear, but shot in the back. And either A, the decision is no criminal charges are being filed, or B, the person is brought to trial and we get a not guilty verdict. And that's why you're getting protest, because it happens all the time in the community, and that's the community's right to protest to try to bring attention to it. But unfortunately, the protest, that's kind of their only option to kind of try to make their voice heard. Now, in this case, I don't know, how it can really change anything because the case went to trial. The case got prosecuted aggressively, and I can Monday morning quarterback how the case was prosecuted. But there's no doubt in my mind that the prosecutors gave attention to this case. They put good, experienced prosecutors on this case. They litigated the case zealously, and they did not get a good result. And they can't do more than that.
Yeah. Is there anything about this trial? Because one of the things is we've all been learning as we've been watching. I at least I can say that for myself and my friends and family, we've been learning so much as we've watched this trial, as we've watched the Murdaugh trial. Is there any type of misconception that's out there legally that you hope these recent trials that so many people have been paying attention to? Not just, I think about it, nationally, people are paying closer attention to trials across the country. Is there anything legally you hope the community is able to learn or glean from watching these trials?
I think the biggest thing is the unpredictability of verdicts and outcomes. I've tried a lot of cases over the years, and there are just so many cases that I was certain that I was going to lose and won, and cases I thought were slam dunks, and got my teeth kicked in by a jury. And that's just that's why cases go to trial. And that is an unfortunate reality, and part of that means accepting that there are going to be results and verdicts that we personally disagree with. And hey, you could try that same case next month with 12 different people and get a different outcome.
And we'll end with this, talking about the jury. We don't know who was on the jury. We don't know the makeup of the jury. Can you speak to the weight of what it means to pick, I hate to say the word right jury, but the importance of jury selection, because it can literally make or break the case. Like you said, this could be tried in front of 12 different people, the same exact case, the same way, and it could have potentially got a different outcome.
Yeah, but I think, we try to pick the right jury based on the information we have. But again, based on my personal experiences, I've had jurors that I wanted on my jury, that I thought were going to be with me the whole time, and not so in the end. Mm-hmm. In the other, I've had cases where there are people I did not want on my jury, people that didn't like me. That I had one jury actually get aggressive with me doing voir dire on a case, and ultimately that jury got sat and gave me a favorable outcome, and told me later he was one of the main people that was championing my cause. So it's just, we do the best we can when it comes to picking a jury, but there are just so many things, so many personal experiences that jurors have from an individual standpoint that affect how they perceive facts and what's important to them, that we're never going to know all that. And it's just, I hate to use the word crapshoot, but sometimes it's just a crapshoot.
Mm-hmm. I'm glad that you spoke to that. Like you just don't know what the jurors have been through, because when I think again about the community reaction that we have been seeing, the biggest question is how could, for the people who are upset, how could the jurors vote not guilty? And then you'll hear people in another trial and say, how could they vote guilty, right? And so I think that is such a good perspective to bring in, is you just don't know these jurors' life stories and how they perceived everything that has happened.
And I think another thing that's important to keep in mind too, unless you're in the courtroom every day, if you're watching from home or reading the news or the paper, you're kind of seeing snippets. Mm-hmm. You're not there every day hearing the testimony of all the witnesses and hearing how they respond to questions on cross-examination and judging their demeanor. That's a big factor in these trials that you can't pick up by just kind of watching the highlights. Mm-hmm. You kind of have to be there all day, every day. These jurors are watching these witnesses, 7-8 hours a day.
Mm-hmm. Yeah, that makes sense. Any final thoughts as we wrap up? Knowing that we've got that not guilty verdict and this lasting a couple days, any final thoughts on this case?
Again, there's a shock. As I dissect this case and Monday morning quarterback, like I say, while I would have done some things differently on both sides, because I want to be clear, there were things that I saw the defense did that strategically I would have done differently. So again, I'm kind of just critiquing different factors that I noticed, but ultimately, it's very difficult to say that any of those things really made a difference in the outcome. I truly believe if I had an opportunity to talk to these jurors, they would give perspective on things that we're not even thinking about, that were relevant or important to them. And the thing about it is, when we heard about those things or hear about those, we might not even agree with them. Mm. But they're the ones that had the authority to make that decision, and that's what we have to live with.
All right. Thank you so much, criminal defense attorney John Mobley, joining us. Thank you not only for breaking down the trial and the case today, but also you've been with us for the past couple of days, really helping us understand the legalese, because we understand that sometimes trial, it can feel like a lot of red tape. It can feel very convoluted. So thank you so much for breaking that down for us. Now, if you want to check out anything that has happened through this trial, as News 19 has been there gavel to gavel, make sure to head to our website, WLTX.com. And of course, we'll have this interview and all the other interviews we have done regarding this trial on our TV streaming app, WLTX Plus.